You might have to approve. All right. So I have Glenn here from Winnipeg. And Glenn is a very experienced property manager, 15 plus years, I believe. And so, yeah, Glenn's going to share some intel with us on the tenancy board and kind of general tenant issues and stuff like that for Winnipeg, Manitoba specifically. So thanks, Glenn, for joining me.
Hey, Maddie, great to be here. Thanks very much. It's an honor because you interview so many people. And so thanks very much for your time.
Oh, thank you. So Glenn, tell me, and like the tenancy boards, tenancy laws, they vary by region, sometimes even by city, but mostly it's like provincial that we kind of worry about. Is that correct?
You are correct.
Okay.
And it's mainly by provincial, and it really varies across Canada.
Mm-hmm.
A lot of the basic rules are the same. However, there are those little intricacies that you have to be very careful of. Otherwise, you can be offside and get into problems.
Totally. And so in Winnipeg, is it the city or the province that writes the tenancy laws?
Great question. It's actually written by the province, and the act that actually regulates it is actually referred to as the Residential Tenancies Act, and it's by the province of Manitoba.
Okay, awesome. So I some of these might be pretty rapid fire, but well, let's just jump right in.
Go for it.
When can a tenant withhold rent legally?
A great question. They can't actually legally withhold rent. However, let's use an example of a landlord not doing repairs, and a tenant has requested the repairs, and the landlord isn't responsive or hasn't taken care of those in a timely manner. Then the tenant can go to the residential tenancies branch in Manitoba and then pursue that. And then what happens if an order for rent redirect is issued to the tenant and the landlord, then as long as the tenant pays their rent to the residential tenancies branch and is paid in full, the rent is considered paid. And that will continue until that order is lifted.
So they'll hold it in trust kind of thing until
that's correct. And there is a charge to the landlord as well for that each month.
Makes sense. Does the Manitoba market have both fixed term and kind of regular term leases?
Great question. They do. And so there's fixed term. Usually a fixed term is there's no set time period. However, it's generally the period of 1 year. You can do 4-month periods. You can do various fixed periods. Otherwise, it'd be a periodic tenancy, in which would be a month to month.
Okay. And I just came across this in Nova Scotia. If at the end of a fixed term, let's say like a tenant was in a situation where they were not ready to move out, so they just sent a rent payment to the landlord. In Nova Scotia, that automatically switches the lease into a month-to-month lease, that like constitutes as an agreement, just sending the rent. Is that the same in Manitoba, or is a fixed term, that's it? The lease is over at that date and the landlord could come back? And
that is a great question. Now there's a couple parts to that question, where if the lease has ended and the tenant sends rent and the landlord accepts the rent, then the tenancy will continue on a month-to-month basis. However,
challenge with like automatic deposit.
Right. Then what you want to do ahead of time is make sure you have all your ducks in order and make sure that's canceled, and especially through the bank and that ahead of time, or with the financial institution. But also a landlord has to send out in Manitoba, if they intend to continue or send out a lease renewal at least 3 months in advance. And the tenant has to have that lease renewal signed and sent back to the landlord at least 60 days in advance. What we do to cover ourselves as well is we make sure the tenant has actually received the lease renewal. And we also, if the tenant decides not to stay, we get it in writing that the tenant does not, plan to stay and they want to move along.
Okay, that makes sense.
That way we're covered.
It's just good, like anything that protects both sides, like
Absolutely.
it's obviously our conversation, we're a landlord, so we're of course thinking like, we need to have all the information and stuff like that, but it also is important for tenants, to not get caught, let's say if they didn't give enough notice but they were planning to move out, that kind of thing. So yeah, it's true, it's good. What about if like what about smoking, non-smoking? If it's like a non-smoking lease but somebody is smoking in the unit, is that grounds for the tenancy to end, or is it like kind of gray territory? How does that work?
Well, one thing you want to set up even ahead of time is before the tenancy starts. We call them house rules here in Winnipeg, but you want to have that it is a non-smoking property if it is, or whether it's a smoking property, what the rules are pertaining to that. So we have in all of our house rules, because people can smoke outside, plus then it's not a fire safety issue, but it's in the house rules stating that this is a non-smoking property. So if the tenant contravenes one of the house rules, then what you would want to do is you'd want to issue a gentle warning letter to the tenant, just so that way they've got it on their file, it's in our files, we're protected. And so usually give them a reasonable period, usually 5 days, to correct the behavior. And we explain just due to fire regulations, et cetera, et cetera.
Yeah.
And so then if they don't correct, then what we do after that, and you've issued the warning notice, then you can actually pursue it through residential tenancy branch, and you can give them 1 rental period notice to vacate for cause.
So you mentioned house rules. Does that mean you can kind of create your own clauses, and once the tenant signs that those particular things are legally binding in terms of the lease?
Absolutely.
Okay.
And what you do is you attach it, and there's a portion on the last page of the lease. It says any additional house rules or any additional
clauses,
regulations.
Okay.
Yes. So what we do is we put C house rules, and we have the tenant initial as well. So then the house rules actually form part of the tenancy agreement.
Gotcha. Okay. What about so let's talk. I have a few questions about ending tenancies. So I think you already answered this one. How much notice to end a lease? Is it the same no matter what type of lease it is? It's that 3 months from the landlord?
Well, if it's a month to month, then only 1 full rental period's notice is required.
Okay.
And also say, for example, we're in June and we wanted to end it for the end of July. We're in June. Yes, end of July. It has to be issued before the 30th of June.
Gotcha.
So 1 rental, and for a fixed term, it would just automatically end unless the lease renewal wasn't signed.
Okay, great. So the default is it will end as it states.
Correct. Yes.
Okay. Can you take me through, like, very simply, I guess, the process if you had to you wanted to evict a tenant due to non-payment, the unit cost too much for them, and it wasn't a good fit anymore, but they were resisting, leaving, moving on. How does the kind of notice to quit hearing that process work in Manitoba? Just a brief overview.
Yeah, great question. So in Manitoba, the rent is due on the first day of the month. So if it's after the first day, rent is considered late. I'll probably maybe cover another one of you. You may have a question. It's $2 for the first, $10 for the first day, and $2 every day thereafter for a maximum of $100. Now, what we do on the 5th day of the month in Manitoba, we can issue a Form 8, and it's termination. You guys call it notice to quit. It's Form 8, and it's termination for non-payment of rent. So we can issue that. And then also, there's no set time limit that the date that the tenant has to move out. Usually we do 4 to 5 days after the fact. And we want to give them the opportunity to get that rent paid and continue the tenancy. If that doesn't happen and you've exhausted, and you should document all of the dates and times and methods that you've tried to contact the tenant. So then what would happen then is you would go to residential tenancy branch and you would file for what is called an order of possession. In Manitoba right now, it's $60. And usually it's about 3 weeks out for booking time to actually get a hearing date. Okay, what you need to provide as well is also a rent roll and the notices that you've actually delivered to the tenants.
Okay.
Does that answer your question?
Yeah, perfect. And can tenants receive notices officially by email if they have their email on their lease, or does it have to be physically in person?
Great question. Whenever it's notices can be, as long as you have a form signed from the tenants, it can be acceptable if they've chosen to accept your emails, then it's acceptable. However, those are just regular notices. Anything to do with termination, anything to that effect needs to actually be delivered in person, physically.
Oh, good to know. And so is there, I know in Nova Scotia, there's when you deliver a notice physically, you still have to fill out like a certificate of
declaration of service.
Yeah.
Yes.
One of those.
So, yes. So we have to do that when we're issuing residential tenancy branch related paperwork. We wouldn't have to fill out a declaration of service just for the Form 8 itself. However, it's always great to, whether it's a quick photo or anything like that, just to have evidence that you've actually, or have another party with you, just to verify, yes, this was served on this date and this time.
Okay, thank you. If you issue notice, Form 8 for non-payment, and then following that, the tenant pays like a portion of their rent, does that negate the notice or the Form 8? Like, does it negate the eviction?
It doesn't, because they haven't paid their rent in full. It's just depending on the tenant and on the landlord. And again, we always want to make everything work with tenants or clients. However, when you're accepting the rent, you can also issue the tenant with a quick notice saying, thank you, we're accepting this portion of your rent. This amount is still outstanding, and the eviction remains at this time.
Okay, that makes sense. Okay, so let's move on to just kind of general lease questions.
Sure.
So for the damage deposit, when someone signs a new lease, is it standard to collect like, the damage deposit, or is it always the first month and the damage deposit, or first and last and damage, or is it up to the landlord to decide?
Great question. It is actually regulated by the province. In Manitoba, the maximum you can collect for a security deposit is equal to half a month's rent.
Okay.
Unfortunately, we'd like to collect a month's, but we can't do that. And so half a month's rent. Yeah. And just a little tidbit, I don't usually share this a lot, but you want to, when you're collecting the security deposit and first month's rent, unless it's by e-transfer, we don't recommend accepting cash. And then unless it's by a method that it's able to be tracked, we don't accept personal check. That's where I'm going, is because somebody can put a stop payment on either the security deposit or on the first months, and now you've moved the tenant in and you don't have your rent.
Oh, I would have thought you fully collect it, like as the lease is getting signed, like deposit it and it goes in trust with the landlord.
Yeah, we try to get that a little bit ahead of time. So a
mm,
move-in date, we're not just down to the wire. But again, no personal checks just because it could be stop payment. It could go NSF.
yeah.
And then in addition, we want to get things, everything set up ahead of time prior to even moving that tenant in.
Okay. Another question to do with security deposit. Do in Manitoba, is there like a standard in and out inspection, or do landlords kind of create their own if they want? How does that part work?
Landlords can create their own.
Mhm.
However, why reinvent the wheel?
Right.
And if you have to go to a residential tenancy branch hearing, you want to protect yourself.
Hmm.
And so we make sure they're Form 5s. They're called rental unit condition reports. And they're standard with residential tenancy branch. They're very thorough. We ensure we use their paperwork as much as possible because when we go to the hearing, we're successful. They're familiar with the paperwork, and it just simplifies the entire process.
Totally.
But if there's any piece of advice that it's a piece of, is golden, make sure you do a move-in inspection and a move-out. And in addition to that, take photos of the unit. So
Mm,
keep it on a USB or something. This is the condition at move in. This is the condition at move out. And then you're protecting yourself as a landlord.
totally. I mean, I have visions of like, walking through with an iPad with the tenant, and like
Absolutely.
checking things off together, take photos, and at the end, like they sign it,
Yeah.
and that's it. So like the in inspections in the best interest of the landlord, I guess I would say.
Yes.
And of course, the out inspection is for the tenant in order to confirm that the unit's in good shape and they can get their deposit back in full.
Absolutely. And
Yeah.
you really want to make sure you do a detailed or you're
Mhm.
performing a detailed move out inspection.
Yeah,
Absolutely.
makes sense. Um, are you allowed in Manitoba to have like a no pets policy? Is that enforceable? Um, if there's a lease signed that's no pets and then pets kind of enter the unit partway through the lease, I guess. Let's say they adopt a new dog or something like that. Is that something that could negate the lease? That would put the tenancy in jeopardy for the tenant, or is it kind of something the landlord wouldn't be able to do anything about?
Great question. We all love pets, or most of us. However, there are certain conditions and processes for rentals that you don't want to have pets in the property.
Mhm.
Yes, you can definitely have a no pet policy. Absolutely. It just gets very difficult when you're differentiating against dogs and cats. However, you can put in the house rules and form it as part of the lease to cats only. So you're indicating the maximum number of pets that you'll actually allow in the building,
Mhm.
and or just no pets at all. Now, if
Yeah.
a tenant does bring a pet in and they're not supposed to, and you're just going to say, you're going to refer back to the house rules. And remember
Right.
when we talked when you moved in?
Mhm.
And what you'll do at that point is politely remind them. Just depends on the tenancy. You might just give them a verbal warning. If it's a tenant that you just want to make sure it's in writing, just as a formality, we're going to give you this notice, and you're going to have 5 days to get rid of your pet.
Yeah.
Or if you're allowing the pet, they can pay the pet deposit. In Manitoba, a landlord's able to charge up to 1 full month's rent for pet deposit, which is awesome.
Oh, wow. Okay.
But we usually charge only half a month's rent just due to affordability and everything else as well.
Mhm. Yeah.
So yes, you can allow it, but it's going to be on the landlord's discretion. But definitely, you're allowed no pets.
I forgot about the house rules side, and with pets, to be honest, I was thinking it's also like, let's say another, a tenant is looking for a apartment that is good if they have like really bad allergies or something like that,
Yeah,
and they
absolutely.
they purposely are trying to find somewhere that has a no pets policy for their own health.
Yes.
um so I mean, in that instance, it's not like mean landlord, it's
No.
it's a matter of protecting like the community as a whole, right?
And when you explain it to the tenants that way as well, then they have more of an understanding. And
Mhm.
again, like you mentioned, you're not such a bad landlord. and you're just looking out for everybody's well-being. And especially you look at apartment blocks, and I love dogs. I've got a dog, but in an apartment block, what do dogs do? They bark.
Yeah.
And so then because noise disturbances, unless there's lots of dogs, and it just depends on the type and the size.
Yeah.
So, but it could cause other issues and noise complaints as well.
Totally. That's right. I forgot about that side too. And a lot of damage as well could be done by a pet if they were not well trained. So, can you charge for the following in a lease? And so you can just say yes, no, and we'll zip through.
Sure.
Parking?
Yes.
Storage?
Yes.
An admin fee for people to pay cash?
No.
A late fee for late rent?
Absolutely.
Garbage removal, like extra garbage removal?
Yes. So additional, say, bulk items, and where you've given the tenant the opportunity to remove it and they haven't done it, absolutely, you can do that.
Extra tenant?
I'd like to say yes, but we can't for additional tenants
in
Manitoba.
Can you price the lease accordingly, like off the bat, when you first kind of have a discussion with the person, where like we have toyed with the idea, I don't know if it's in place yet, where we give like discounts for certain things. So if you're a single person, for example, you might get a discount because you'd have much less of a draw on like the water, electricity, that kind of thing.
Yes.
Or, if you have no pets or whatever, that might be a small discount, where the normal rent would be like with those things. Is that something that's doable, like adjusting what the rent amount is going to be as you're negotiating?
It is, absolutely. Okay. But there's a gross amount and there's an anniversary date for rents and for increases. So you just have to be cognizant of that. However, yes, you could definitely do that whenever it's a new tenancy. Mm-hmm. And so you can work with that discount. Absolutely.
Okay.
And then you just have to have the conditions of the discount, why you're giving the discount.
Okay. I just noticed the time. Are you still okay for just a few more minutes?
Let's do it. You're doing fantastic.
If somebody's been a tenant for a long time and you want to make a building non-smoking, are you allowed to change a lease to non-smoking when somebody's already kind of tenured with you?
I actually had this come up in the past. And so it's actually grandfathered in. If they've been there that long, you say even just newly purchased the building, it was a smoking building, you're changing it to no smoking. However, new tenants that are going in, right, if it's a new tenancy, that can be changed at that time, but otherwise it is grandfathered in, unfortunately.
That makes sense. And I mean, if you lived somewhere and you've been smoking and you're used to smoking indoors, like it would be a pretty tough adjustment to suddenly have to potentially walk down 4 flights of stairs or whatever every single time. I imagine that would be pretty rough for the tenant to try and adjust to.
Absolutely. But for the other ones, all new tenants, my wife's a smoker. She smokes outside. There's no reason you can't smoke outside. Absolutely.
Totally. If a second tenant moves in, would they need to sign a new lease?
You have such great questions. I love these. So not necessarily, there's 2 ways you can do it. So if what you can do is add that tenant to the current lease and have the landlord and all parties initial the change. Mm-hmm. So that's one method. The other method could be creating the new lease with the same dates, same information, with both tenants on there, and signing the new lease and just indicating on the lease that it supersedes the previous lease.
Okay. If the main lessee, I don't know if that's the right lessee. Leasee moves out, is the original lease like null and void, regardless of whether there's other new people living there?
Not at all. And this happens with students and roommates and that all the time, all too often, where there's a little bit of a dispute or one reason or another, or somebody's moving out of province, that one person has left the tenancy, but we don't take them off. Actually, we leave them on there unless all parties involved are willing to put it in writing and saying, yes, this is why I would like to be removed, etc. As a landlord, you usually don't want to change that lease, and it doesn't void the lease, it's still a current lease. You usually don't want to change that, because then you have, if they skip on rent and that, then you have more parties to pursue.
Yeah, I was just thinking from the other side, like if I was a tenant, and this has happened to me back in my university days where I was like, I had people kind of rotating in,
Yeah.
and then finally I was wanting to move to a new place, and I made sure they signed a new lease because I didn't want
Right.
my name on their behavior, whatever happened.
Yes, absolutely.
So yeah, that's good. That's interesting to know.
But all parties would have to be, all parties would have to be consenting, and I would get it in writing as well, because you want to document everything just so you're protected 100%.
Okay, a few more quick ones. What if a tenant damages property like outside of their unit, for example, front door or like the garden or the steps or whatever? Does the landlord have recourse, let's say, against their security deposit or anything like that?
Absolutely.
Okay.
So that there's two ways to do it. You usually don't want to wait to the end of the tenancy to pursue those type of claims. You want to fix the damage immediately, and you want to make the tenant aware, because tenant's responsible not only for their behavior, but their guests' behavior as well.
Right.
So what you could do is you could go ahead, and you'd have to get a couple estimates on it just to protect yourself, because residential tenancy branch will ask you for that. But you can either have the tenant repair it, but the challenge is it may not be in a workmanship like manner. So a lot of times, depending what the damage is, you go ahead and do the repair and invoice the tenant. And again, you don't want to, yes, if the tenant didn't pay, you can take it out of the security deposit, but you don't want to wait to that point in case there's, they left the unit, it's not clean, there's other damages, etc.
Totally. And if the damage was accidental or something like that, you might be able to leverage your good relationships and rates with contractors in order to get the work done for cheaper than the tenant could have done themselves too.
Absolutely. And just let them know it's in their best interest to do it this method. And we're all working together and going in the same direction.
One of like the ultimate gripes of many landlords, no matter where you are in Canada, every region has their own like pest challenges. When I first moved to Halifax from Ottawa, I had mice in my apartment. I was like completely freaked, had never even seen a mouse until I was 18, and realized a town like right on the water port is susceptible to mice, rats, that kind of thing.
Yes.
So anyway, I'm sure Manitoba has like specific challenges with pests. What's the responsibility of the tenant in terms of like reporting it, taking care of things if the landlord sends in professionals to deal with the pests, that kind of thing?
Well, they have to, it's their responsibility as a tenant to report it. They can't just keep it to themselves, and then the problem persists and gets even bigger. And then after that, then they're naming them, and then you have to get a pet deposit. No, I'm joking. But back to pests. Regarding mice and everything else, it's their responsibility to tell you, and it's our responsibility as landlords to take care of that. But we can't take care of a problem if we don't know. Yes, we can charge the tenant in the event that, say, for example, bed bugs, that they haven't notified us, they've had it, we can substantiate that it's been quite a long period of time, or a period of time they haven't notified us. We could file a claim and go after them that way. However, it's again working everything out together.
Yeah, that's the best always, for sure.
Absolutely. But pests, also, we're going to go one step further to your question, is say, for example, we've treated the suite 2 times and tenants either aren't ready, or for the extermination, they haven't done all the preparations. You've tried working with them. There's other resources that you've even tried with the tenant. At that point, you could charge the tenant. Again, we always want to make everything work. And again, unless you can prove initially that the tenants brought the pests into the property, then it is the landlord's responsibility to take care of.
Right. Yeah. That's definitely a tricky situation. You need
It is
professionals to help you identify those things. Like it can't be landlord's word against the tenant. That wouldn't get
No,
anywhere.
no, it doesn't work.
What was my other? Oh yeah, what about like subletting? Are there any rules? Do you have to sign something new? I guess we actually kind of covered this. Some things just can happen automatically.
Regarding that, there's a real misconception. I don't think everybody understands what an actual sublet is, because a sublet is when a tenant actually plans to return. So they're having somebody sublet their suite, and they plan to return back to the suite prior to the end of the tenancy. So it's actually an assignment where they're assigning the lease, and you can either do the assignment of the current lease, or you could start a new lease, as long as there's an agreement and all parties are in agreement there. And there is a $75 fee for the tenant to pay for the assignment. And we give them a few copies of applications. It's up to them to make additional applications.
Yeah.
And also they're responsible for the costs of advertising and for showing the units. The landlord will do the entire process, because you just don't want anybody in your unit. So it has to be an acceptable tenant, or the tenants have to be approved. And then also, when you're doing the assignment, it's really important that you give the tenant written permission, and it could even be by email, that you're agreeing to the sublet. Now, I'm just going to go one step further, and then to let them know that they're responsible for all utilities and all rent up until takeover of the actual new tenant. Because what happens is, in a scenario, they go ahead, they've already got their new place, they're trying to assign, rent's due, they haven't found a new tenant. Who pays rent, who pays for the utilities? So it's really important you have that in writing, and there is a form that you sign, that they're still responsible up until takeover.
That makes sense. It's only fair, right?
Yeah, absolutely.
So my last question is, what's the rule, or like which tenancy law for Manitoba do you find is the most infuriating, or like pain in the butt from the property manager standpoint?
Which one? There are many. One would be the responsibility regarding, exterminations. That would be definitely, we talked a little bit about that. Another one would be, it's not so much a law, it would be the time that a claim, or even sometimes order of possession, would actually takes to get to a hearing. Right now, residential tenancy branch is not even accepting any claims from landlords. And because they're as far out as August and September, and because of COVID. And so if you have a tenant that's skipping and you want to serve them a claim, and you already know there's damages in the unit and everything else too, so you can't even serve that tenant.
Wow.
Because you can drop off the claim at residential tenancy branch, they'll put it into their system and their queue, and then you'll get a date eventually. But once you get that date, you need to find and locate and serve the tenant now.
That is something that I find I struggle with a lot. Like when I read people's comments online and things like that, where it's almost like landlords, just like blanket term landlords, are seen as like this huge corporation. They have tons of money, and like the tenants are hard done by and kind of at the mercy of this corporation. But there's so many like privately owned, or like one person has a few rental properties, and they can be just debilitated financially if tenants like damage units, don't pay, and that kind of thing. I really feel the pain, like when you talk about that kind of delay with the tenancy board. I could just see people getting really taken advantage of, and paying a way too high a price by like taking a risk trying to provide housing for somebody.
Yes, there's especially a lot of real estate investors in that too. It's a little bit different with apartment blocks because some of the units can offset others. But when you're the smaller landlord and you have maybe 3 rentals or something to that effect, and you've got a tenant who's not paying rent, and you don't know all the rules and regulations, and we actually teach courses on that. We're starting online courses called
Oh,
The Wealthy
cool.
Landlord. But yeah, it can, a lot of times what happens in that situation is they get so far behind, and then tenants hasn't paid rent in 3 months, and then they just end up selling the properties and they get out of real estate. And
Mm.
just because it's such that financial burden.
Yeah, yeah, totally. And even for apartment complexes, if you are, I mean, if you're a landlord like Vita, where you're committed to remaining affordable and much below market rent, even though you could charge more,
Yes.
um, you don't have the room to like be not collecting rent from sometimes even one unit can put a pretty serious strain on the finances for the company. So,
Absolutely.
yeah.
Vita's amazing at client relationships. The model is fantastic.
Mhm.
And it is, the affordable housing and that too. And I just love what you guys do. But again, it's the one basic obligation for the tenant. There's many, but is just to pay your rent and pay it on time.
Yeah.
So it's not a huge ask. But yes, it can create some huge financial burdens.
Yeah, for
Absolutely.
sure.
Yeah.
Listen, Glenn, thanks for giving me your time so generously today. And I know this video will be really helpful for others. I'll share it out with our team. And yeah, just thanks so much.
Thank you so much. One thing I do want to add, just as a little tidbit,
Sure.
there is a Form 10, if you want to look that up online
Mhm.
and just take a look at that. That will give you other behaviors that outside of non-payment of rent that are going to be covered, like duty not to disturb others. And that's some really important stuff that the BAs need to know as well.
Oh, thank you. That is really key. I think I might have forgot or skipped that question, but
That's okay.
that's
There's so
key.
many.
Thanks so much.
Have a great day. Thank you.
Okay,
Take care.
you too.
Bye-bye.
Yeah.